Welcome back to This Week in Immigration. I'm your host, Jack Malday, Associate Director at the Bipartisan Policy Center. In this week's episode of This Week in Immigration, BBC Senior Advisor Theresa Cardinal Brown discusses the implications of a recent executive order that has sought to limit birthright citizenship in the United States. Immigration attorney and MacArthur Fellow Margaret Stock explains what current law says about who qualifies for US citizenship, drawing on her years of experience helping US citizens document the citizenship of children born abroad. She also discusses the challenges US parents could face under the order and the potential financial and legal burdens it would create. Then, Jacob Hamburger, visiting assistant professor of law at Cornell, joins to talk about how the policy could strain state and local governments that issue birth certificates and the broader federalism issues it raises. So stay tuned.
In one of his first executive orders, President Trump created a new government-wide policy that said that only children born in the United States to a mother who is a lawful permanent resident or U.S. citizen could pass along U.S. citizenship to their child. This would seem to contradict the 14th Amendment to the U.S. Constitution that states that, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside, unquote. While federal courts have blocked implementation of this executive order as of now, litigation continues and is in large part hinging on whether the president would have the authority to change the interpretation of this amendment by executive order and the exact interpretation of this clause. But under-examined in this debate, however, is what adoption of this policy would mean for U.S. parents trying to document the birth of their child in the United States for U.S. citizenship purposes. What would it mean for the thousands of jurisdictions in the United States that issue birth certificates and the costs it might impose? So to discuss this aspect of the executive order, we welcome to the podcast Margaret Stock. Margaret is an attorney at Cascadia Cross-Border Law Group, working in Anchorage, Alaska, and focuses her practice on immigration and citizenship law. She is a nationally known expert on immigration and national security laws, has testified regularly before congressional committees on immigration, homeland security, and military affairs. She is a retired lieutenant colonel in the military police, U.S. Army Reserve, and she has extensive experience with U.S. military issues. For her groundbreaking work developing programs to better the lives of immigrants and native-born military personnel, she was awarded a MacArthur Fellowship in 2013, also known as the so-called Genius Grants. But of particular interest to us today is her lengthy experience helping military members and other U.S. citizens who have children while abroad documenting their U.S. citizenship, and co-authored a report with the National Foundation for American Policy that showed that changing the rules for birthright citizenship could cost every U.S. parent up to $3,000 more to document the citizenship of their children. So welcome to This Week in Immigration, Margaret.
Thank you for having me on this show. I'm really excited to be talking about this topic.
Great. Thanks so much. So first, let's talk a little bit about what current U.S. immigration law says about who gets U.S. citizenship at birth.
So current law is extremely straightforward and clear. It says that anyone born in the United States, with very, very few exceptions, is an American citizen at birth, regardless of who their parents are. So it doesn't take into account the situation of the parents at all, except in a one exception is children of diplomats. But otherwise, anybody born in America, regardless of who their parents are, is an American at birth. And then it also contains a lot of very complicated provisions for people who are born overseas. So if you're born in America, you get the benefit of the really simple rule. If you're born overseas, you're subject to a very complex regime of complicated laws that have changed over time. And in those cases, the situation of your parents is taken into account. So they look extensively at your parents if you're born overseas and you're trying to claim American citizenship. Sometimes they even have to look at your grandparents. But it's a very complicated legal system that is subject to multiple errors and complexities that would boggle your mind. And it can be extremely difficult to figure out whether somebody born in a foreign country is an American citizen or not.
Yeah, so you have a lot of experience doing that kind of analysis for children born abroad to U.S. parents. So how does that inform what you think this new executive order would do?
Well, the new executive order is interesting because it's got a rule in it that has never been applied in any statute in American history. It takes into account the immigration status of the mother, but it's very specific about what the immigration status of the mother has to be at the time of the child's birth. And we don't have any statute that says that right now. So implementing this is going to be extraordinarily complicated because it's a brand new interpretation that's never been applied before in American history. And there's no regime set up, bureaucratic regime set up to adjudicate claims like this. The closest thing is the overseas naturalization regime, which is really complicated and does take into account the mother's immigration status as well as the father's.
Yeah. So I'm sure a lot of Americans think, well, I'm a US citizen, so I shouldn't have any problem with this new executive order if I'm going to have a child in the United States. Why do you think that's not true?
Well, it's definitely not true under the new rule because the new rule says you're not a citizen if you're born here. You're only a citizen if you're born here, and your mother and your father have certain statuses. So, what that means as a practical matter is some bureaucrat is going to have to look at your mother and your father, and they're going to have to look at your mother and your father's paperwork at the moment that you were born and try to figure out if they had the correct immigration status. So, it's very similar to what we do to overseas people. If we have a child born on a U.S. military base in Germany, we have to look at the mother and the father and try to figure out what their immigration status was at the moment of the child's birth. This is really complicated to do. First, you have to track down all the paperwork. You have to prove that the paperwork is legitimate paperwork. You have to figure out what the rule is and apply the rule to the person. And you're talking about 3 people instead of just one person who was born here. So it does get really complicated. And I think you can envision a regime where each person going into a passport office would have to prove who their mother was, who their father was, and what the parent's immigration status was at the moment of the child's birth. And that's pretty complicated to do. It's a moving target. It wouldn't be as simple as just bringing in your mother's birth certificate proving she was born in America, because that doesn't prove anything under the new rule. You'd have to somehow come up with some kind of documentation to prove that at the moment you were born, your mother was still a U.S. citizen. And, same thing with your father. The other thing that's odd about the rule is the rule mentions the biological father. And that's never been an actual requirement. Most of the time in immigration adjudications, they look at your birth certificate and they look at the father listed on the birth certificate. There's a presumption in Anglo-American law that if your parents are married and your father's on the birth certificate, that's your biological father. But the executive order is unusual in that it specifies it has to be the biological father. It's not clear how they're going to determine that. Are they going to require a DNA test from every dad born? Every child will have to get a DNA test to match their biological father when they're born in order to adjudicate the citizenship claim. That's going to be really expensive. And sometimes we've had to do that with overseas kids, and it gets really complicated, and it takes months often, to set up the DNA test and confirm that the father is really the biological father.
Yeah. So, out of curiosity, like under current law, why is this process for documenting citizenship so complex if you're not born in the United States?
Because they take into account your parents. And that requires your parents to fill out an extensive questionnaire. Where were you born? How much time did you spend in the United States before you were born? Where did you grow up? How many trips have you made to America? Prove to us that you had a certain immigration status at a certain point in time. Prove that you didn't renounce your American citizenship somehow before your child was born. So you have to document a whole lot of things, and the stack of paperwork is high. It's usually 2 inches thick. And sometimes you have to go back and find historical records. Many people, believe it or not, don't actually know the true facts of their birth. Sometimes when they start to investigate, they find out that the person that's listed on their birth certificate isn't really their father, or there's nobody on the birth certificate. Maybe the person was added later. It can get super complicated. And the executive order, another thing people don't realize is that there's no backup plan in America. If you're born here, you're either a citizen or you're not. And if you're not, you're an undocumented immigrant, basically. So that's the other puzzling piece of this, is that what are we going to do with all the people that don't qualify for American citizenship after this huge bureaucratic exercise? Are they just undocumented immigrants? There's no law that gives them any status. And that's because the whole Immigration and Nationality Act contemplates that everybody born in America is going to be a citizen, with very few exceptions. And I think you're familiar with the law, Theresa, but it's the Immigration and Nationality Act. And when it was passed in the early 1950s, Congress thought everybody born in America was going to be an American citizen. So they didn't take into account they didn't pass any law that gave any kind of status to anybody else. So there's nothing in the law that gives a green card to people born in America who aren't American citizens, with the exception of diplomats' kids. There's just nothing. So you're basically under the executive order. You're either a citizen or you're an undocumented immigrant at the moment of your birth, depending on
Yeah,
what
I
your
mean,
parents are. Depending on
right.
parents.
So we could have a huge class of children born in the United States from the U.S. immigration perspective with no status. Would they necessarily get the citizenship of their parents if their parent isn't a U.S. citizen? That might not be the case either, right?
Right, that doesn't happen either. So, and I have actual cases like that where I have folks who were born on a U.S. military base overseas and they end up being stateless because a U.S. military base is not American soil. So they don't become Americans at birth under the 14th Amendment. So we're relying on their parents, but their parents may come from a country that doesn't allow you to have citizenship in the country through your parents. There's a lot of countries that don't actually allow that, or they require the claim to be proved up before the child is a certain age. So if you don't prove the claim before a certain amount of time, you're stateless. And you have to get your parents to cooperate. So if you couldn't get your father to cooperate in determining that you're a citizen of his country, you end up stateless. I do have a case like that going on right now with somebody who's in America who thought she was a U.S. citizen. She was born on a U.S. military base to parents. Her father was serving in the U.S. military at the time she was born. Turned out her father was not an American citizen, which people didn't know when she was born. They know that now. And so she's stateless because she cannot get her father to cooperate in getting her any kind of documentation from the country that he is now proven to be a citizen of. So she's just ending up in this limbo situation. In America, can't work legally, can't get a passport from any country. It's a total mess of a situation for her. And that's the mess that millions of people are going to be in if this new rule goes into effect.
So the executive order didn't just apply to parents in the United States who were undocumented. It also applied to parents here legally, but on temporary visas, such
Right.
as a student visa or work visas like H-1B, O-1, or L-1, many of whom are in the United States for years and years and years in these temporary statuses. What does that mean for those people who are here legally?
Well, that's also a huge problem for them. You can imagine if you were a professor at a university and you're here on a temporary work visa to work for, on an H-1B visa. Maybe you're from India and you're waiting about 20 years to get your green card because of the country quotas. And you want to settle down and have a life and you don't want to wait your 20 years to get your green card before you have kids. So you start having children. Under the new rule, your children would all be undocumented immigrants. They wouldn't have any kind of legal status. So the minute you're a temporary worker and you have a child in America, that child's going to be an undocumented immigrant. And you won't be able to get them health insurance. You won't be able to get them a social security number. You won't be able to presumably enroll them in a whole host of programs that are necessary to, bring up a child in America. So you're going to basically have to leave the country in order to have any life for your child. And that's not tenable. I would hope Congress would pass some law to cover you and give your child some kind of status, but that requires us to assume that Congress is going to act, and they haven't so far. I haven't seen any bills in Congress that would address this huge gap in the president's executive order.
I think there have been some bills introduced that would codify the interpretation, but it don't necessarily change the immigration laws. So as you're pointing out, that leaves a big gap in, okay, maybe you're not a citizen, but what are you? What
What are
status
you?
do you
Yeah,
have?
right.
Maybe people may think, well, if the parent is on a temporary visa and a child is born, wouldn't they get a derivative status from that temporary visa, like an H-4? That may or may not be the case. If they're undocumented first, they can't necessarily get, and we don't have a process for that, right?
Right. We don't have a process for giving any kind of status to people born in America other than citizenship. So there's no procedure for like getting a US birth certificate showing you're born in Denver, Colorado, and changing to H-4 when you're, 3 months old or something. We don't have that at all. You have to prove you're admitted to the US legally, and you got no proof of that. So you're not going to be able to.
Yeah, if you weren't admitted because you were born here, what does that do? Yeah.
Yeah.
Yeah. I mean, these are all the logistical things that I think a lot of people just weren't thinking about when this whole thing started coming up. The lower courts have stopped implementation of this executive order for now. And as I mentioned at the top, a lot of the arguments are about whether or not he had the authority to do it by executive order. But can you envision some of these logistical issues could be part of the litigation as well? Are you aware of whether these have been brought up yet?
I think they're going to be part of the litigation. I mean, the only reason they've raised them in the litigation, but they've raised them from the perspective of the states having to deal with this large undocumented population of babies and what's that going to cost the state government. Because we don't actually have a person born in America yet who is not a citizen, we haven't seen any individual litigation by a baby saying, I'm being denied insurance. I've got thrown out on the street, out of the hospital, out of the neonatal intensive care unit because, I can't prove my immigration status.
Right.
And I'm not on my parents' insurance because the insurance company says I need a social security number and I can't get one, So we haven't seen any individual plaintiffs like that, but certainly you're going to see a massive amount of litigation if this ever goes into effect. Just massive. I think it'll mirror the student visa uproar that happened in the last couple of weeks with the student visas, where hundreds of cases were filed all around the country, people just going into court and getting injunctions right away. It's going to be worse than that because it's going to be everybody in America having to do this. And, it'll be full employment for immigration lawyers. Every baby born in America is going to need an immigration lawyer now. And I don't think people have thought through that at all. I'm sure they haven't because there just aren't enough lawyers to do all this work.
Yeah. So as I mentioned, the lower courts have issued temporary injunctions or restraining orders on this. Do you know what the next steps in that litigation are? Like, how long will it be before we kind of know for sure whether this is going to happen?
Well, the Supreme Court says they're going to hear arguments in May. So it's May, right? 1st of May.
Yeah.
So in a couple of weeks, we should be having some sense of whether the Supreme Court's going to dive into this morass or whether they're going to say, no, we've had enough. We're not going to change the whole entire legal regime in the country here. And it's interesting to me because under this regime, at least one Supreme Court justice is probably not a U.S. citizen. Yeah.
Oh, interesting. Yeah.
Yeah. I mean, that's the interesting thing about this whole theory is if you start unwinding everybody's parents, it turns out that there's a huge percentage of the population that's going to end up not being American citizens, including members of Congress, famous Americans, Nikki Haley, Kamala Harris, all kinds of people end up not being Americans who thought all their lives that they were American citizens. And it's a radical change. I think if they want to make this change, the logical way to do this would be an amendment to the Constitution followed by implementing legislation in Congress. That's the logical way to do it. And that's what other countries have done that have changed over from birthright citizenship. They've actually done it logically and carefully and slowly. So if we want to do that as a country, that's something certainly we could make a choice to switch from a simple rule to a more complicated rule. But we need to do it the logical way, which is make a constitutional amendment, have a big debate about what that's going to be, and then have Congress pass implementing statutes. The whole INA contemplates that everybody born in America is going to be a citizen. So the whole INA has actually been thrown into question by this executive order. And that's another reason why it's probably not a constitutional or a legal executive order, because you can't change a constitutional amendment and a whole bunch of statutes with an executive order, particularly one that's as whimsical as this one. The rule that they're positing is just a brand new one that nobody ever thought of before. The combination of your mother and father undocumented or they're on temporary work visas. Well, we've got more than 80 temporary work visas. Are all of them included or just some of them? What about these other statuses like TPS or asylum applicant, or you've got an adjustment of status pending, but you don't have it yet. It hasn't been approved yet. So the logical way to do it is get a constitutional amendment, have a constitutional amendment debated in the Congress, like they did originally with the 14th Amendment, mimic that process.
We should specify that the executive order, at least purportedly, would be prospective. So it would apply only to children born in the United States after the day of the executive order. But I'm hearing from you that you think that it still could apply sort of retroactively. Can you explain sort of why you think that?
Well, because it makes no logical sense that if the 14th Amendment's been misinterpreted all this time, that it would suddenly be interpreted correctly prospectively based on the random date of a presidential election and the decision of the president to issue an executive order. Now, I guess you could do that if you were Congress and you were passing a constitutional amendment. You can say this interpretation of the constitutional amendment will only take place prospectively. But whether an executive order can interpret the Constitution, I think people are just going to argue that if that was the wrong interpretation all along, then it's been wrong forever, and everybody's citizenship is called into question.
Right.
Not just a
Right.
random date, and then people are going to, of course, litigate over whether, my child was born 1 minute before the executive order went into effect, or, the birth began 1 minute before it went into effect and it wasn't completed because we had a C-section until 2 minutes later. I mean, all this kind of stuff is going to be litigated, and it'll get pretty crazy pretty fast.
So in your report for NFAP and the Forbes article based on it, there was an example of what happens to a mother who's giving birth when their green card gets approved, during labor. Like, how is that? There like a time stamp on the birth certificate? Is there like an hour and minute stamp on the green card approval that could be matched up, right?
Well, there isn't right now, but that's because there's no contemplation that this is even a problem. But the executive order makes it a problem, so now we're going to have to timestamp everything.
Yeah.
And we have had regimes where we've had to do that. You might remember 245I, that bureaucracy had to go in and timestamp the receipt of different things because there was a cutoff date, and it turned into a giant nightmare, and there's litigation over, did the post office.
245I for our listeners just was a provision of immigration law that allowed people who may have been undocumented in a certain period of time to still adjust status depending on when their petition for green card had been filed and the date. It only was in place for a certain time period. So whether it predated, so as you said, everybody had to document to the minute what their eligibility was for that.
Right. And it was a mess. And this is going to be a mess. I just know from having dealt with people that are trying to prove their citizenship from overseas that it's not easy at all. And you often have to hire a lawyer. And our estimate of $3,000 a baby, that's low. Okay.
Mm-hmm.
There's going to be lots of cases where it's going to be a lot more expensive. And the father having to prove he's a biological father is a big piece of it that's going to make things really expensive, because you're going to be filing paternity lawsuits all around the country and trying to get DNA tests from people. And, that's a sea change in jurisprudence. And again, right now, the law contemplates that if your dad's on the birth certificate, that's your dad.
Right. So other things. Well, Margaret, thank you so much for taking us through that and joining us today. We're going to take a quick break. And when we come back, we'll talk to Jacob Hamburger, who's a visiting assistant professor of law at Cornell University, who looked into the impacts this would have on states and localities that issue vital records, such as birth certificates. So stay tuned. Welcome back. I'm happy to welcome to the podcast Jacob Hamburger. Jacob is a visiting assistant professor of law at Cornell Law School, and his research explores the legal processes at the federal, state, and local levels that shape the lives of non-citizens in the United States. At Cornell, he's taught civil procedure as well as a seminar on immigration federalism. His scholarship has been published or is forthcoming in the Duke Law Journal, the Washington University Law Review, and the Boston College Law Review. And starting this coming fall in 2025, Jacob will be joining Marquette Law School as an assistant professor of law. Recently, he wrote an article exploring the impacts of this executive order on birthright citizenship on federalism, and we welcomed him to our podcast. So thanks for joining us, Jacob.
Thanks so much for having me, Theresa.
So, Jacob, your research and writings have focused a lot on the relationships between states and localities and the federal government around immigration. And I know we've talked on this podcast that it certainly seems that depending on who is in the majority in Washington, the arguments about who should have primacy, the states or the federal government, change. So what are your overall thoughts about where things stand right now in that kind of debate of who has the authority to do what in the immigration space?
Yeah, so I think these arguments tend to shift over time because the two parties tend to want slightly different things, and especially when the other party is in power. So I would say that the usual state of affairs, if we can call anything usual in American politics or law these days, has been that blue states and cities try to claim somewhat more autonomy or authority to withhold their cooperation from federal immigration enforcement, or to try to integrate undocumented immigrants as members of their communities in various ways, while red states and maybe also sometimes cities are seeking autonomy in a different sense to try to enforce immigration law more vigorously than they think that the Democratic administrations are doing when the Democrats are in power. So this means basically that when we're seeing conflicts between state and federal governments over immigration, they look a little bit different depending on who's in power. So when under Democratic administrations, Usually this will be that some red state law enforcement scheme, at least the Democratic administration will say, goes too far in usurping the federal government's role. It's preempted by federal immigration law. And on the other side, in some respects, we don't see quite as much argument that, for example, state efforts to give driver's licenses to undocumented immigrants is preempted by federal immigration law. But you do see some places where Republicans have successfully blocked efforts by blue states to protect immigrants. I'm thinking of things like California's law trying to ban private immigration detention that was struck down under the first Trump administration. So that's kind of been the balance of power, the status quo, I think, kind of up to this new administration. But I think it's fair to say that the second Trump administration is trying to shift the balance of power between states and the federal government more in favor of the federal government. I think what that really looks like is trying to compel cities and states to cooperate with federal immigration enforcement in ways that the federal government hasn't really sought before. So we see this in a lot of different fronts here. So on one front, we see lawsuits against blue cities and blue states and cities in those states like New York, Illinois, or just recently Colorado, where the federal government is saying that effectively that state or local decisions not to assist federal law enforcement are themselves preempted by immigration law. That's posing an obstacle to how the federal government enforces immigration law. But we even see this in some more unprecedented types of moves outside of the courts to try to really compel state and local governments to comply, even when they don't want to assist federal immigration enforcement. So that's everything from seizing money directly out of New York City's bank account, trying to claw money back from the federal FEMA shelter and services program, to charging just recently a judge in my soon-to-be home city of Milwaukee with obstruction of justice, and then sort of reverse of that, dropping the charges against the mayor of New York City, Eric Adams, to try to compel more cooperation with federal enforcement efforts. So I think that what we haven't seen so much before is this move of saying that it's unlawful for states and cities to opt out of the federal enforcement scheme. Mostly we've seen that be understood based on long decades worth of Supreme Court precedent as being a voluntary effort to assist the federal government. And also the types of mechanisms that the federal government under Trump 2.0 is trying to use are somewhat more aggressive than we've seen before.
Yeah. So let's focus now on this issue of birthright citizenship. And in this law review article that I cited before, you look specifically at the impact that a change in birthright citizenship law could put on the strain on state and local governments, who are the ones that issue vital records that we all use to prove our identity and our citizenship, which are birth certificates. So what do you see as the major implications here?
Yeah, I think we don't often think of this issue of birthright citizenship, which has been so prominent in this new administration. We don't think of this as being an issue for state or local governments. And maybe that's because, in some respects, quite reasonably, we think primarily of the impact on the people who are going to be most directly affected, children of undocumented immigrants or children of people on temporary visas. But actually, state and local governments really are at the center of this issue of birthright citizenship. And, we can think about that just in thinking about how many of us who might be actually US citizens, if we're ever interacting with the federal government, we would need to prove that we're citizens. Think about how we actually have to do that. So the only document that most Americans have, if they don't already have a passport, say if you're going to apply for a passport for the first time, so the only document you have that proves you're a citizen is your birth certificate. And who issues that birth certificate? It's going to be a state, county, or municipal government, through the state vital records office. And the way this works, how we get these birth certificates is that each state and states might dole out the responsibility differently to counties or municipal governments, but none of this is federal, so to speak. Every state, though, has some procedure where hospital staff will record information about a newborn baby when they're born in the hospital, and they transmit that to the vital records office, and then soon after, the state or the county produces a birth certificate. And under the theory of birthright citizenship that we've basically assumed, or we've seen in action for the last over a century since Wong Kim Ark, this is basically at least a document that definitively proves that you're a U.S. citizen, because a birth certificate issued by Tompkins County here, where I'm sitting right now in New York State, that proves that you were born in New York, that proves you were born in the United States, and therefore a citizen. Basically, state and local governments are providing this fundamental proof of birth in the United States, which is the same, which guarantees citizenship. And as far as I'm aware, at least currently, no state or local government in collecting that information, figuring out what goes on the birth certificate, no state or local government currently requires putting information about your parents' immigration or citizenship status. They might list the name of the parents, maybe even the parents' birthplace, but as far as I can tell, there's no jurisdiction that records whether your parents are US citizen or lawful permanent resident, even in states that do require hospitals to ask about immigration status in hospitals. And I can even go on further about the role that state and local governments play when it comes to citizenship, because there's also quite a few different partnerships between the federal government and state governments that cut directly to this issue. So I think the most important one is an initiative through the Social Security Administration called the Enumeration at Birth program. And Enumeration at Birth, or EAB, this is a partnership that all states have with the SSA, which means, and what happens there is that once the hospital collects that information, it's the same information they send to the state vital records office. That state vital records office also shares that with SSA, and a Social Security card and number is going to be generated for that newborn essentially automatically right after birth. So once you're born, if you're born in a hospital, you get a birth certificate from the state and you get a Social Security card from the federal government.
Yeah, I was going to say that's very interesting, because I'm old enough to remember that I did not have a Social Security number or a Social Security card until I was about 14 and I wanted to work. And then I needed to go down to the office and show my birth certificate to apply. And now you need a Social Security number for so many things, including for your parents to claim you as a dependent on your taxes in most cases. So, that enumeration at birth process, I'm sure that most parents don't even think about it right now. It just happens automatically.
Yeah, and it's interesting when this program first originated. Immigration policy nerds like us might take some notice of the date when the pilots of this first rolled out in 1986, because what law was also passed in 1986? It was IRCA, which first required all employers to verify that their employees are eligible to work. So I don't know for sure that is that one prompted the other, but you've got to think that now, once everybody needs a Social Security number just to work, which pretty much everybody has to do, you need a much more efficient system of making sure people have Social Security cards. And so we can't just require everybody to think to apply for it someday. We need to have this much more efficient system, which guarantees basically now that it's something around 99% of all babies born in the United States get that Social Security number issued essentially at birth through this program. And then, we can add on top of that things like Medicaid, all kinds of other benefits where states are administering federal benefits. States might also choose, when they're issuing their own benefits under state law, to make US citizenship a criterion of that. So basically, getting back to this question of, what happens if the Trump administration is successful, we implement this new definition of birthright citizenship. So now just take SSA, take Social Security cards. If now the SSA regulation says that you're not eligible for a Social Security number unless you can satisfy this new definition of birthright citizenship, which means that you have to show both that you were born in the US and that one of your parents was either a citizen or a permanent resident. Well, now all these enumeration and birth partnerships might be in jeopardy, because either each and every one of these state, local, or county or municipal governments is going to have to figure out how to make sure that hospitals are collecting and recording the right immigration status. And you can imagine sometimes it's a tricky question, even for us immigration lawyers, to figure out exactly who's a citizen. So maybe Tompkins County is going to come up with a different set of documents they're going to ask for from Tioga County, a few miles away. States across the country might also have different motivations in determining how to figure out who's a citizen. And the procedures they're going to enact might also vary from state or even county or city lines. This is also going to be quite difficult to implement, because imagine they're collecting this information when somebody is at the hospital giving birth. So is this going to mean that in order to get that Social Security card at birth, your parents are going to have to remember to bring the passport or bring their own birth certificate when they're rushing to the hospital when somebody's going into labor? Maybe some states are going to say that that's what you have to do. It's kind of crazy to imagine that, but we haven't seen what the actual regulations look like that would implement this executive order. So it's possible that either at the federal level or at the state level, when they're trying to sort of comply with that this might be required. So in short, it would be an enormous mess to try to collect this type of information that the Trump administration's definition of citizenship would require from state and local governments.
Yeah. Now, the executive order does say that this would apply prospectively to persons born in the United States after whenever date this executive order becomes active, if it ever does, because it has been enjoined by the courts right now. We should make sure that's clear. But do you see this affecting all Americans and not just those born after this executive order was signed? I mean, one thing I'm very much aware of is that most Americans don't have a U.S. passport. It's a minority of Americans who have a U.S. passport or any other federal document documenting citizenship. As you mentioned, even for employment authorization purposes, most people who are American citizens will file their Social Security card and a driver's license. The driver's license, of course, form of identity most often comes from somebody's birth certificate. So, like, neither of them in and of themselves necessarily would prove citizenship, but that's the most common documents U.S. citizens would have.
Yeah, and I should say, I think from what I could tell, the number of Americans who have passports has gone up slightly. I think it's actually a little bit above 50%.
Oh, right above
but still,
50%. Yeah, that's still almost half of Americans don't have that.
Yeah.
Yeah.
And exactly, if these regulations go into effect, getting that passport is going to become much harder. So we probably would expect that number to drop. And as you say, if this is affecting how states are now require what information states are requiring for people to get birth certificates, that can affect how people get things like driver's licenses and the like, which are issued under state authority. But let me just back up and clarify really why this does affect all Americans, and not just people born after this order is supposed to go into effect, and not just people who are deemed to be not birthright citizens under the order, children of undocumented immigrants, children of temporary visa holders. So really, to back this up, once again, the understanding of birthright citizenship that we have been operating on for over a century has that understanding is that if you are born within the geographic limits of the United States, you are a United States citizen. Having a birth certificate has, and federal regulations have really taken this into account. Having that birth certificate basically proves definitively that you're a citizen. It can get somewhat more complicated for people who don't get a birth certificate at the moment of birth, maybe because they were born at home with a midwife. But that's basically the exception that proves the rule. The vast majority of people get this birth certificate at the moment of birth, and that establishes they're a citizen. But now let's imagine that we're implementing the birthright citizenship order that the Trump administration is trying to implement. And so now what this means is that birth certificate is no longer definitive proof. So they're going to change something like the SSA regulations or Medicaid eligibility regulations, whatever it may be, to say that according to the executive order, you need to show not only that you were born here, but that your parents were citizens or permanent residents. So now you have to find, when you're applying, and maybe you're applying for your small child after they're born, you have to submit that additional proof that the parents, in this case, you as the parent, are also a citizen or permanent resident. You have the required status under this order. So how do you do that? That's not entirely clear. And this is part of, as you say, the order, the executive order has been enjoined, the federal government's been enjoined from taking any steps even to draft the regulation. So we really don't know what that would look like. So what's unclear here is whether this new definition of birthright citizenship applies to me as the parent if I'm applying for my child who's been born after February 19th, 2025. It's clear that the order says that if I want to apply for a passport, having been born before February 2025, I should be fine. I can just submit my birth certificate. But if I'm applying for my child, that means I have to prove my citizenship as well. And it's just not clear whether, in order to prove my citizenship, I have to satisfy the same standard. So does that mean that I have to show that I was born in the US and my parents were also citizens or permanent residents? We haven't had a system that works along these lines. We haven't had a system that requires proof of parent status to claim birthright citizenship. So we're not really set up to fix this problem of kind of this recurring question of how do you prove who's a citizen? And if you keep going back to different generations, it might become quite complicated. Maybe I can go on Ancestry.com and find some record of someone somewhere who definitely was naturalized. Ironically, naturalization documents would be the best form of proof. So if my grandfather naturalized, I could sort of show a chain of descendants. But this is all just speculating about how, when I'm applying for my child who's definitely subject to that order, how do I prove my status? If I don't have a passport like this large group of Americans don't, then it's not clear whether my birth certificate would do the trick.
Let's talk a little bit about the court cases, because you are a law professor, and I'm sure you've read the initial injunctions. Obviously, we mentioned Wong Kim Ark. We haven't talked about that really on this podcast yet, but can you just give us a little background on that case? That was a 100-year-old case that is sort of the basis for us understanding that, yes, no matter who your parents were, if you're born in the United States, you're a citizen. Do you want to give us a little bit of background there?
Yeah, so Wong Kim Ark was born in California to parents who immigrated to the United States from China. So they came before the Chinese Exclusion Act, which would have prevented them from entering, but Wong Kim Ark's parents were unable to naturalize under the immigration laws at the time. So when they came to the United States, they were permitted to be in the United States, but not to naturalize. And so Wong Kim Ark was born to Chinese parents under this legal regime in California. And he had actually, throughout his life, had traveled back to China. He married and spent some time back in China after being born in the US, but had come back multiple times. But then at some point, the federal government decided to pursue a theory of birthright citizenship fairly similar to the one that we're seeing the Trump administration proposing today. That this involves the 14th Amendment that says that all persons born in the United States subject to the jurisdiction thereof are citizens, that subject to the jurisdiction thereof language somehow excludes, in this case, someone born in the United States to Chinese parents. And the Supreme Court, in that case, rejected the government's argument, rejected this idea that, as the government argued there, that people born to subjects of the Chinese emperor were subject to another jurisdiction's sovereign, subject to the jurisdiction of the Chinese empire. That was the government's theory, but the Supreme Court said no, birthright citizenship applies virtually universally, only with exceptions for people born to Indian tribes, which before 1924, Indians or Native American tribes were members of those tribes were not granted citizenship by statute at that point. And this caveat was there to recognize the separate sovereignty of the tribes. And similarly, the two other categories of people that the court thought were not subject to the jurisdiction of the United States were children of foreign diplomats who, similarly, although it's kind of strange to compare maybe tribal jurisdictions to something like an embassy, but you can think of those as both being places or configurations of people on U.S. soil who are not subject to the U.S. jurisdiction. One, because it's a separate sovereign entity, and one because we think of an embassy or a diplomatic corps as being also not subject to the U.S.'s sovereignty. And then the final example would be children of invading army, an invading army that's come by force into the United States, and if they were to have any children there, they would not be considered, their children would not be considered subject to the jurisdiction of the United States. So according to the court in Wong Kim Ark, aside from these carve-outs, everyone born on U.S. soil is subject to the jurisdiction of the United States as entitled to treatment as a citizen. And the decision in Wong Kim Ark did not immediately result in every single person born in the United States being treated like a citizen, partially because the system that we have today of issuing birth certificates to everyone born in the United States was just not we didn't have that system at that time. It didn't really become widely effective until around the 1930s. We start to get large percentages of people receiving birth certificates at birth. So there were, for many years, especially Chinese immigrants like Wong Kim Ark returning to the United States who found it difficult to prove that they were citizens. So the question of proving citizenship remained an issue until we got the effective system we have today. But the principle that everyone born in the United States is a citizen of the United States and based on that birth, that has been, there have been arguments in some corners of the academy or the commentariat or politicians to rethink that holding, but otherwise that has been the holding of the United States Supreme Court, and that you can read many other decisions where the Supreme Court just acknowledges that a person who was born in the United States was born in this country, was a citizen because they were born in this country. So this has been the understanding that we've written our immigration statutes based on this understanding. We've created these complex intergovernmental partnerships based on this understanding. And the Supreme Court has maintained this understanding in cases for about 130 years.
Yeah. So this complexity of our system that relies essentially on this kind of definitive understanding of being born in our territory means you're a U.S. citizen, except in very, very narrow circumstances. Do you see some of the complexity that you've just talked about, how we've built all these other systems based on this idea being made in the court cases around birthright citizenship? Like undoing this undoes a lot of federal policy, not just citizenship and immigration policy.
So on the one hand, I don't necessarily see I think there's more arguments that could be made. For example, the idea that the 14th Amendment, part of what the 14th Amendment sought to do was to end the legal regime that we had before the Civil War, where state definitions of who counts as a citizen were much more prominent in American society. And this was really a core part of the conflict that gave rise to the Civil War and ultimately to the 14th Amendment and the other Reconstruction amendments, because some states treated Black Americans, at least free Black Americans, as citizens of the state, and other states, particularly the states that maintained the slave system, denied that any Black person could be a citizen. So these conflicting state definitions of who's a citizen was at least one of the things that the 14th Amendment was enacted to eliminate. Now we just have one definition of citizenship, and to some extent we have a clean and easy rule to determine who's entitled to it. So to some of those arguments, I don't necessarily see parties making as much, and partially this might be for some strategic reasons. But one way in which these accounts of the complex interactions and partnerships and structures across the federal and state governments really have figured into the litigation has been in the ways that the states who are challenging the Trump administration's birthright citizenship order have tried to articulate why they have standing, why they are entitled to litigate as plaintiffs against the federal government here, and why, for example, they should be entitled to make this case and not simply somebody whose child might be affected by the order on an individual basis. This has some important implications because if states don't have standing to sue the Trump administration over this policy, which is one thing the federal government is currently arguing before the Supreme Court. They're going to have oral arguments later next week. If the Trump administration is successful there, then that might mean that anyone who wants to challenge this policy would have to do so on an individual basis rather than trying to dispose of the question on a more broad-based nationwide basis. So the consequences of that could be quite profound for how the litigation progresses. But to the question of do states have standing? Do they have any stake as states, as government entities within the U.S. system to raise legal arguments that this order is unlawful? The states have been acknowledging in their complaints and throughout the litigation that in large part they do because of these partnerships that they're a part of. The states receive some amount of funding for each child who's issued a Social Security card through the enumeration at birth program. The states get reimbursed for medical expenses through Medicaid for eligible Medicaid recipients, and Medicaid recipients have to be citizens. And plus, states have become aware of these potential new requirements of all these new procedures they'd have to design. And so this has gone into the states' arguments for why, when the federal government unilaterally decides to change the definition of birthright citizenship, that's not just affecting the people who might or might not be entitled to citizenship under that rule, but it's regulating the states themselves. It's affecting the funding they might receive through these federal partnerships, and it's getting to the core responsibility of states of issuing regulations for and procedures for documenting births, as well as things like deaths and marriages, which is a fundamental state responsibility. What's core to understand here is it's not just that state governments receive money through these partnerships. That in itself is important. But really, I think if we look at the system that we have in this country, states are really core actors in the process of producing and determining citizenship itself. And so if the federal government wants to unilaterally change this definition of citizenship through executive order, then states have a role to play in raising legal challenges to that, both to the fundamentals of the meaning of the 14th Amendment, but also to the procedure used to do that, whether it's appropriate for this to happen by executive order. This is something that affects states, and they should have a role in raising that.
I was going to say that, that question of standing is one that's come up in a lot of other immigration court cases. And it seems like the courts are kind of changing how they think about that a little bit. But I'm mindful, for example, that state of Texas brought some lawsuits and litigation against DACA. And one of their standing claims was that, well, we have a state law that would require us to issue driver's licenses to DACA recipients, and therefore it will be a state cost. You could easily see that states are saying, well, if we now have to change the way we document births in our state or in our locality, that will incur costs, and therefore we have standing, like, regardless of their role in these other federal programs. If this rule would require them to change the way they do something, at least there's some court cases that would say, yeah, that probably could get you standing. Have they made that argument as well?
Yeah, well, so there's two things to distinguish here. So one thing is, in terms of standing arguments based on indirect costs, I think that there's some room for the court. There's some members of the court, I would say, and I think on both sides, that are somewhat skeptical towards those types of arguments. If it's an argument along the lines of which is the kind of arguments you saw in many of the cases that Texas litigated, for example, against the enforcement priorities under the Biden administration, where the injury to the state, because to establish standing, you need to establish that the state was injured in some way. So if the injury was that this policy encourages more undocumented immigrants to be in the state. And by being in the state, they go to school, or they might get injured, they might get sick and go to a hospital, or they might get arrested and be taken to jail. That imposes all these costs on various state-funded programs. I think that's the kind of argument that there are some people on the court who want to rein in these types of indirect cost arguments for state standing. But I think that's different from something, I think, both like the Texas driver's license argument you mentioned, and what we see going on here, because you might disagree with the state of Texas's decision to deny driver's licenses to undocumented immigrants, but that is something that at least no one at least has. I think there's an equal protection argument you could make towards that, but I think that would be challenging given the state of equal protection law these days. So if you accept that that's something the states can do, then I think the state has an interest in upholding the law that it's enacted about who is entitled to a driver's license and who doesn't. And similarly here, states have set up legal laws and regulations and procedures. They've created a system for how we determine who is entitled, for what we put on a birth certificate, who gets a birth certificate, what that birth certificate looks like. And here, implementing this executive order would effectively require states to change the way they do that, just like Texas argued that the DAPA program would effectively force them to give driver's licenses to a class of people that they didn't want to give driver's licenses to. And the federal government has argued in this litigation, in its application to the Supreme Court, that states are not directly regulated by the Birthright Citizenship order. But I think this is a clear example of how they are regulated, because if the federal government is changing all these regulations for what types of information has to be on a birth certificate to count for a passport, currently that does not include something like citizenship information about the parents, then you are essentially requiring states to change their procedure for doing that, which is a core function of what states do as state governments. I think what the court might be more skeptical of would be an argument that either because of some attenuated idea of causation of the federal government passes this law, then this person does this, then this person does this, and then that produces this cost for the state. I think that's something the court might be more skeptical of. And also an argument that the state is simply representing all of the people within the state, so anything that harms people within the state, that's a harm to the state. These are the types of arguments that the court has become much more skeptical of over time.
Yeah. So we talked around a fair amount of things. Obviously, we'll know what the Supreme Court says. Well, they'll hear it. We'll probably know several months later. I don't know. We'll see. That's an emergency action, so they are expediting it. We may hear from the court. But do you think that we've been talking about this evolving nature of immigration federalism, if you will. Mm-hmm. How do you see this birthright citizenship? Do you see this as sort of a culmination of that, or do you think it's just sort of another step in this ongoing, continuing debate on, where the rules and regulations lie?
Yeah, on the one hand, we might think that what happens in this case is somewhat distinct from what we're seeing in, for example, the Trump administration's lawsuits against Illinois, Colorado, and New York. Or what we had seen before in the Biden administration's litigation against Texas or Iowa or Oklahoma over their immigration enforcement schemes. I think one way of reading this case is that this is about the definition of citizenship under the 14th Amendment, not about whether the federal immigration statutes conflict with this or that policy that states decide to make. But here's one way where I think it does intersect with this earlier history of immigration federalism we've seen before, which is that essentially what the Trump administration is doing, if we understand birthright citizenship through these state and local partnerships, through these structures that actually allocate citizenship and allocate benefits that hinge on citizenship. Well, what the Trump administration is doing is essentially unilaterally altering the terms of these partnerships that have been agreed to by state governments throughout the country. And this is something that we saw the Trump administration try to do before. This was the slew of cases involving the 2017 executive order trying to withhold law enforcement grants from any state or local government that adopts what's generally called a sanctuary policy, declining to assist the federal government in carrying out immigration enforcement, maybe declining to collect information that might be used to support immigration enforcement. A lot of different definitions of what constitutes sanctuary. But the Trump administration identified certain jurisdictions that it thought were sanctuary jurisdictions and wanted to withhold these law enforcement funds that are used, that a lot of state and local governments rely on. And for the most part, in most of those cases, courts really sided with state and local governments, saying that this is, part of what's wrong with that is the federal government or the executive branch is usurping Congress's power to decide what money gets spent on what. So one, you're interfering with these existing contracts, right, in a way that gives those state and local governments certainly standing to challenge that. But this is a core separation of powers problem that the executive branch can't just unilaterally dictate what gets spent once Congress has appropriated it. I think now we're seeing both in the immigration space and far beyond it, this has been the MO of the Trump administration sort of across the board. Whether it's almost everything that Elon Musk and Doge are doing, whether it's USAID canceling withholding funds to universities through the NIH. A lot of what the Trump administration's MO has been to try to unilaterally cancel spending that has at least arguably been allocated or appropriated by Congress. So I do think that that in some respects, these immigration federalism cases from a couple of years ago might end up really being a bellwether for what we're seeing here in this case and in many of the other challenges to what the Trump administration is trying to do.
Yeah. Do you want to predict what the Supreme Court's going to do with this case?
So I do think that the Supreme Court is not going to rule in favor of the Trump administration on the merits of this case. I don't usually make a lot of predictions, but this is one I'm fairly confident in. And basically my legal realist brain here just says, looking at the consequences of this, looking at the fact that you're going to have to require every single hospital in the country to develop a new procedure to figure out the immigration status of somebody giving birth in the hospital. I think that the justices are probably, at least a majority of the justices, are probably sensitive enough to that to think that that's a step they don't want to go to. I think you can look back to Wong Kim Ark itself, where the same Supreme Court that not too long before had upheld the Chinese Exclusion Act certainly was not a court that was predisposed to rule in favor of the rights of Chinese immigrants. It looked at that case and said, whoa, hey, hang on a second. If we say that the children of Chinese immigrants aren't birthright citizens, doesn't that mean that we also have to say the children of German or Scottish or Italian immigrants also aren't citizens? So you can see, in a way, I think the justices might see some of that going on too. And I think there's plenty of historical evidence that can support the justices who are the most attached to history and tradition or approach, or an originalist approach. There's plenty of evidence that they can certainly be used to justify upholding the same interpretation that has been the prevailing interpretation for well over a century. As to what happens on the actual emergency appeal that we're seeing right now, I think some people have said that there's a better chance that the Supreme Court rules for what the Trump administration is asking than there is that they'll rule ultimately on the underlying merits. I still think it's a little bit of a tough ask. Clearly, there's at least two justices on the Supreme Court that do not like nationwide injunctions. That's definitely Thomas and Gorsuch. And so potentially they might want to make this the case to say, whatever we think about the merits here, we want to take a stand against the ability of the District of Massachusetts to dictate federal citizenship policy for the entire country. I think the argument against that as a prediction is that the Supreme Court has had many opportunities to say something more broadly about nationwide injunctions. It hasn't done so, and it is an issue that really does affect both parties. So it's not something that is necessarily going to there have been opportunities under both the Trump administration with challenges to the Trump administration's policies and challenges to the Biden administration's policies. At no point during either administration has there been a majority willing to say we're going to restrict how district courts can issue nationwide injunctions. So it might simply end up kicking the can down the road again. And then on the question of state standing, I think this is also not the best case to try to limit state standing. Although I don't know what the justices are going to say, but certainly we don't have the type of argument for standing that we have had in other cases, including the Texas versus United States case just 2 years ago about the Biden administration immigration enforcement priority document. That case itself, which the Supreme Court did decide, and it specifically avoided the question of, well, what do we think really constitutes an injury to the state? They found a way around actually having to deal with that question there. So I kind of think that here, if this court was ready to fundamentally restrict state standing in a way that might redound to the Trump administration's benefit, or fundamentally restrict the authority of district courts to issue nationwide injunctions that would redound to the benefit of the Trump administration. I think that the court has had opportunities to do both of these things before, and it hasn't done so. So, it's always hard to make these calls. It's always a little bit of wishful thinking, but I do think that probably this is not the case to deliver a big win to the Trump administration.
I will put my 2 cents in here again with the caveat that I am not a lawyer, but there's a part of me that thinks this on the nationwide injunction principle. This seems to be, if there ever was an argument in favor of nationwide injunction, a policy that would differentiate who becomes a citizen and who doesn't based on the state or locality they were born in, much less the status of their parents, would seem to me to be a very big difference because that would matter for that person possibly for the rest of their life. And that seems to have implications for other parts of our federation, if you will.
Yeah, absolutely. And this is something that Judge Sorkin in the New Jersey v. Trump, the case out of the District of Massachusetts, he raised this issue directly, saying that, look, because certainly the Trump administration was asking for an injunction that only applies at least in the plaintiff states, right? So only in Massachusetts or only in New Jersey. But well, what if somebody's born in Texas and then moves to Massachusetts 2 days later? Their family, the baby has moved with their family. If that injunction only applies in one state versus another, well, you're going to have this. Not only that's going to be certainly a major harm to that child. It's also going to continue compounding that injury to the state in terms of Medicaid funding that won't be reimbursed by the state. But also this raises this fundamental privileges and immunities of citizenship argument that we're supposed to have under the Privileges and Immunities Clause. One state is supposed to grant a citizen of another state all of the privileges and immunities that they would grant citizens of their own state. So now if we have separate injunctions that treat some people as citizens here and not people there, that means you've got a U.S. citizen not being a citizen of one state, not being granted the privileges and immunities of a citizen of Massachusetts, only because of that difference in where the injunction applies. And so there's many other reasons that we could go into about why this is not a great case for a more limited injunction, individualized injunction, or a geographically restricted injunction. But I think this core difference, as I've said before, about creating different citizenship regimes across state lines, certainly just at the preliminary injunction stage, you want to avoid some outcome like that. This is also not a good case for it on those grounds. I think the people who have argued that it is a good case are looking at the fact that it seems likely that the justices will rule against the Trump administration on the merits, so they can kind of isolate the issue. I've seen this argument raised, but I think that's ignoring a lot of really the what it actually would look like to implement this, just the way you suggest.
Yeah. Well, Jacob, I think we'll end things there, and we will certainly pay attention to what the Supreme Court ultimately says on this case that they listen next week. But thank you for taking us through that, and thank you for joining us on the podcast.
Well, thank you, Theresa. It's been a pleasure, and definitely we will be paying close attention to what happens. I definitely will be watching those whole arguments on May 15th next week.
Thank you so much.
And that's a wrap on this episode of This Week in Immigration. We are sad to be saying goodbye to our audio editor, Joshua Joe. Josh has been with BBC for almost 3 years and has done an excellent job in ensuring we get well-edited episodes out to listeners every 2 weeks, including editing out all of our mistakes. We wish Josh well with his next steps. In Josh's absence, our next episode will be a re-release, but we hope to be back with you in June with new episodes. In the meantime, one last reminder to subscribe, rate, and review this podcast on Apple Podcasts, Spotify, or your favorite podcast platform, and share it with your friends and colleagues. You can also find more information on all the issues we discuss here on the show at bipartisanpolicy.org/immigration. You can follow the Bipartisan Policy Center on the X platform at BPC_bipartisan. You can follow Theresa Cardinal Brown at BPC_T Brown, and you can follow me at Jack Malday. Send your comments and feedback to us by email to immigration@bipartisanpolicy.org. I'm Jack Malday. This Week in Immigration was created and executive produced by Theresa Cardinal Brown. This episode was written by Theresa Cardinal Brown. Joshua Joe is our audio editor. Talk to you next time on This Week in Immigration.